That was Jane Doe number 1. And to discuss this matter, I have, of course, Gene Rossi still and Professor Burkhalter still, but I'm joined by one of my other favorite guests, Lisa Lockwood. Thank you. You're in California. We're glad you're safe from the fires. You're in San Diego, but you're also a former police officer, former SWAT team person. You are a role model. You are a superstar. I am just so happy to have you back on my show. Thank you for coming. And of course, of that, I want to ask you some questions and put you under the hot seat. Okay. This victim, and I believe she was a victim, and she's coming forward as a victim. The jury voted 7-5. They were hung on her counts, and I would like to say deadlock because I think hung is not a good word for a sexual assault case. We should get in the habit of saying deadlocked. But obviously, the jury didn't like some of the things about her. She misidentified the lawyer as the assailant. She said it was a Jeep, not a Hummer. She said it was 4 doors, not 2 doors. She said that there were back seats when there weren't. But Kellen Winslow II's DNA was on her clothes. Tell me why they're hung.
That's for me.
That's for you, Lee. I'm giving you the hard questions.
Yeah. When credibility is tested, so the credibility of the witness who was there, the victim, they start to kind of wane in other areas. So they're trying to think, okay, what can we believe? Yes, DNA is there. And now they're just trying to prove or disprove whether or not that she was a victim or she was partaking, obviously, in the matter to get a ride as a hitchhiker. So yeah, DNA was there, but was this forcible or was she a willing party? So once the other parts of the puzzle came into question regarding whether or not she was truthful, I think that's what caused them to not give a complete 12-0 for that conviction.
So Kirk, Professor Burkhalter, you're also a former police officer. You're investigating this case. Now, we know that Kellen Winslow II, if he is a sexual predator, preys on people that aren't strong, that maybe they're not going to be believed, that maybe they were of a different class. And someone said, well, maybe she took money for this act, you know, and therefore she's not a good person. And I'm really being bad here because I think that she is a victim. You tell me what the prosecution does differently next time to make her more likable to the jury, since likability seems to be an issue.
I think likability is an issue, and feel free to disagree, but I think if you really want to know what our attitudes are as a society towards women and, you know, power and so forth, watch a trial like this. Because likability, I believe, was an issue, and I think that's what caused the jury to get hung up here. I think the prosecution could work with her a little bit better as far as being clear and direct in her speech and her talking over the prosecutor on direct and things like that. I think I would not be surprised that if you question the jurors, they just didn't particularly care for her, meaning her testimony. Not that she shouldn't be believed, but she just wasn't the same as the other witnesses.
Yeah, and Gene Rossi, there was a question about whether or not she had blackouts from drinking, which she said she didn't drink anymore. It turns out she drank a lot, and that she was having blackouts. Do you think the jury could have thought that maybe she did consent to Kellen Winslow, or indicated a consent that he took as a consent, and she didn't say anything? Or, I mean, some kind of thing like that? I mean, I don't know what else to say.
Well, I think Lisa hit the nail on the head that they were not convinced that it was not consent. And I got to say this, I said earlier that 70% of a witness's credibility is based on their demeanor. The words are almost, redundant or surplusage sometimes. But here, I got to tell you, some of the comments she made, you know, the ouch, 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 that looked a little too rehearsed to me. And, you know, juries look at that, and I think her personality, her demeanor, she has some rough edges that the prosecutors need to sort of smooth over in the retrial.
Well, we're going to listen to the cross, but it's a sad state of affairs that if somebody has rough edges or jury believes that she has somehow is a lesser class to be believed, that she can't be believed in a rape case. But let's listen to the cross-examination. Well, I tell you, I thought after Jane Doe number 4, the jury was deadlocked 10-2, and let me read this to you, on forcible rape, but 8-4 on the rape of an unconscious person. Gene Rossi, you and I discussed this case at length when it was going on. There was supposedly someone else in the room named Matt, who may have been a participant, maybe not, but certainly his Fifth Amendment rights would have to be read to him if he were interviewed, okay? I would have given him immunity and had to come here and tell what happened. What say you, federal prosecutor, former 110 trial prosecutor?
I always gave immunity when I needed it, and I would have given Matt immunity. Obviously, that creates cross-examination material. But I'm not surprised by the 8-4 because I think on cross-examination, I thought the defense attorney, Mr. Carlos, did a great job on establishing that she really didn't have a lot to drink. There wasn't an opportunity to be completely intoxicated and out of it and blacked out. So I'm not surprised by 8-4.
So Lisa Lockwood, obviously the jury, most of the jurors thought 10-2 for conviction. And let's put the drinking aside. Let's just talk about the forcible rape. What do you think hung the other two jurors? Was it the time difference? Was it the fact that she had had a relationship with him in the past? Was it the fact they're 17? Tell me, because obviously I thought she was a great witness and a victim that the guilty verdict should have been found.
Yeah, it's much easier when the person doesn't know the offender, doesn't know the victim doesn't know the offender. So because of that relationship, maybe that was the thing that tilted them to the other side, that there had been something there before. And she was there, and maybe potentially initially she was a willing party. We always hear that in the first part of it, they're interested, they're going forward, and in the last minute they decide they're going to change their mind and not go forward with the sexual relations. So those two jurors were not convinced, obviously, and it's unfortunate that she did know him prior to that, because I think that was the issue that tilted them in that direction.
So Professor Burkhalter, we have now the new trial. Jane Doe number 2, there was a conviction for forcible rape. That's either going to come in or she's got to testify again because there was a deadlock count by sodomy. Do you think the prosecution, by bringing Jane Doe number 2 in again to talk about it, helps this Jane Doe number 4 get a conviction for her charges?
I don't know. I'm not really sure, because to Lisa's point, I think that there are some folks that have a hard time understanding that because someone has some type of consensual sexual activity with a person one time or two times, that's not carte blanche for each and every time. So I think that's the hurdle they have to get over, and I think that's something the prosecution has to explain. So even if he had committed all these acts previously with this particular victim, just because she had a consensual act with him one time, I don't know if that would change the minds of some folks. Obviously, that's wrong. That's the wrong approach.
It's absolutely. So Gene Rossi, riddle me this. You bring Jane Doe number 2 in, let's assume she testifies, and she says things that may undo the conviction because you're trying to get a forcible, the sodomy conviction. Is that a problem? And by the way, before you answer that, I just want to tell you something. You have to leave me at 2 o'clock, and I am just so, again, my heart is breaking because my second best man is in the studio with me today, but thank you for being on the Law and Crime Network. Now you can tell me the no again and tell me why.
Jane Doe, you raised the risk. I would definitely call Jane Doe because, we got the 7th game of the World Series, go Nats. She is the Babe Ruth of this case. Jane Doe 2 is their best witness. So they have to call Jane Doe too.
Wow, Gene Rossi. And you know what? We're going to probably talk more about Kellen Winslow in the days to come, because obviously a jury has been selected for his retrial, where he was found guilty of 3 counts, but deadlocked on a number of the other counts dealing with the other victims in this most very important case dealing with sexual assault on women. But in the next segment, you're going to have to stay tuned, because we have the special treat. Dr. Michael Baden, my husband, will be here for his explosive findings on the Jeffrey Epstein case. I will be joined by Brian Ross, chief legal correspondent here on the Law and Crime Network. He's our investigative correspondent. He's going to help me question, not cross-examine, Dr. Baden on whether or not he believes this is a homicide. Findings of death consistent with a homicide or consistent with a suicide. We also have a diagram for you, never before seen, from the autopsy of Jeffrey Epstein that you will find most interesting about the fractures in his neck. Only here at Law and Crime next.